Mr. Speaker, sir, put your tea down and adjust your glasses because the political arena is shaking. The prodigal son of a street revolution, the man who took a literal, unauthorized tour of the August House, has stepped back into the light. Allow me to break down this highly combustible, deeply dramatic, political, and legal jigsaw puzzle in just a few minutes. The first thing I want us to look at is the legal trap. The big question is, can the state prosecute Mr. Speaker, sir? You see, the state does not merely sue someone for breaking into parliament or breaking into senate. They criminally prosecute them until the defense attorney cries. African elders were right when they said that the monkey that breaks into the grocery store must pay for the bananas with his skin. The director of public prosecution decides to cook a legal stew. The menu under the Penal Code Cap 63 and the Parliamentary Powers and Privileges Act is very extensive. First, Mr. Speaker is likely to be charged with treason or treasonable felony. If the state wants to be dramatic, they will claim bypassing the constitutional mandate of parliament smells like an attempt to overthrow the established order. Secondly, the state may charge Mr. Speaker, sir, with unlawful assembly and rioting. You see, when three or more people gather and cause a reasonable fear of breach of peace, that is an unlawful assembly. Once grass breaks, it is legally a riot. Third, they might charge Mr. Speaker, sir, with forcible entry and malicious damage. Entering a building violently, even if you claim it is the house of the people, is a misdemeanor. You cannot argue public ownership to justify unauthorized entry. It is like saying that because you pay taxes for public roads, you have the right to park your car inside the state house garage. Be that as it may, Mr. Speaker Sir is lucky to have the finest lawyers defending him. I'm talking about Babu Owino, I'm talking about James Orengo, and I'm talking about Edwin Sifuna. To dance around the law enforcement dragnet, these lawyers must pull off major legal acrobatics. Remember, a bird that flies off the earth and lands on an anthill is still on the ground. Mr. Speaker, sir, cannot run forever. So here is the playbook for Mr. Speaker to avoid a prison term. The first thing is anticipatory bail. His legal team must rush to the High Court under Article 165 of the Constitution of Kenya 2010. An anticipatory bail order prevents a dramatic midnight abduction-style arrest, allowing Mr. Speaker to present himself in broad daylight with his liberty intact. The second thing is the 24-hour rule. Under Article 49(1)(f), an arrested person must be brought to court within 24 hours. If the police hold him over a long weekend just to teach him a lesson, his lawyers must instantly demand a dismissal based on gross violation of his constitutional rights. The third thing is challenging vague charges, following the landmark Katiba Institute ruling, which struck down the law on subversive activities for being too vague. Any overly broad, politically motivated charges must be fiercely challenged as an abuse of the court process. Finally, when it comes to Mr. Speaker, sir, I see a political gamble. I see him getting from the streets to the ballot in 2027. In our political landscape, notoriety and popularity are often twins drinking from the same calabash. The stone that the builders rejected often becomes the cornerstone of the youth movement. Can Mr. Speaker, sir, use this street cred to win an election in 2027? Yes, he can do so. You see, nothing says anti-establishment hero like having a tear gas canister thrown at you on national television. However, Mr. Speaker must pass the litmus test of Chapter 6 and Article 99 on leadership and integrity. If merely charged for facing trial, he is presumed innocent under Article 50. A pending court case is practically a badge of honor on the political campaign. If he is convicted and sentenced to less than 6 months, he can still legally run for elections in 2027. If he is sentenced for 6 months or longer, Mr. Speaker, sir, is disqualified unless an appeal against the conviction is actively pending. If Mr. Speaker, sir, avoids a formal conviction, his political machinery will leverage the ultimate victim card. Mr. Speaker, sir, is likely to tell the voters that they're prosecuting him because he spoke for the people. In a country where voters love an underdog and view the state with healthy suspicion, that narrative sells faster than hot mandazi on a rainy morning in the city of Nairobi. Mr. Speaker, sir, my name is Biketi, and I rest my case.